Appreciate your patience this morning. Please be seated. I just had a walk-in emergency matter that I needed to review, and I wanted to get those folks on their way. Our next matter this morning is the matter of Lisa and Robert Gaudreau, Family Court Case Number 2001-004409, and it is a petition on a petition to enforce child support and maintenance, and this is Family Court Case Number, I think I called it right, 2001-004409, and I've asked Mr. Viles, who I know is present, to confirm that for the record and to confirm that his client, our original petitioner, mother, is also present.
Yes, Your Honor, James Viles for the petitioner who's present. And the petition, again, was for enforcement of child support, and it was some medical expense reimbursement.
Understood. And I would ask Father to please identify himself by name for the court record.
Yes, sir. I'm Robert Gaudreau.
And good morning to you. Please be seated. I did get the petition for enforcement of child support and medical expense reimbursement, and I'm not going to decide these issues here today. The real question is whether or not mother and father might be able to resolve this issue, and if they can't, then I'm going to need to set the matter for an evidentiary hearing. Mr. Viles?
Your Honor, my client actually has tried to resolve it with them, and actually sent him a couple of emails before we even filed. Respondent didn't pay, hasn't paid, he didn't pay any child support for 2009, and it appears not for this year either, and I don't know that there's any way to resolve it, so we'll just need a hearing.
Okay.
Yeah. This is medical expenses as well.
Okay. Dad, I don't know what your position is. My position is, first of all, if either mother or father have a significant or substantial and lasting change in their economic circumstance, such as being laid off, not getting fired, but being laid off, or having their position eliminated, or they become sick or ill or disabled, I would expect that person to promptly come into court and file a petition, hopefully for simplified rather than a standard procedure, but a petition for simplified modification of child support. And if that's done and it's appropriate to modify child support, whether it's to jack it up or cut it down, it would happen if it's appropriate and the facts support it. The one thing that I always find disturbing, though, is even if a mother or father becomes ill or is laid off of work and should have their child support reduced, when I have a pattern of no payment of a quarter, a third, a half, or the full amount of the child support, that suggests to me, and it may not be true, that the parent required to pay support is willfully disregarding the court order for child support because they're paying nothing. Mm-hmm. And that could very well result, if I find that there has been the non-payment of child support and I determine that it's willful, could result in my ordering that person to be incarcerated in the county jail and not released until they pay off the entire child support arrearage amount, or at least a reasonable portion of it based upon what I think they can afford to pay. And I don't know the facts, and I'm not going to decide what they are today, but I'm just letting you know up front that if I schedule a hearing, I expect you to be here, and I'm going to expect you to provide mother with full and complete financial disclosure of your circumstance over the last year or so. But is there any particular reason why you haven't, if your circumstances changed, asked the court to reduce your child support and, while waiting to have that decided, paid mother something?
Sir, I'm fairly destitute. These, as far as the unpaid medical and different things, some of these she's first time I've ever seen. I mean, she just hit me with a whole bunch. But as far as the amount coming forward, I'm literally very destitute in that, and yes, Your Honor, I've always wanted, I mean, to catch it up. Always wanted to. I mean, I love my children.
Well, I'm not even concerned about getting it caught up as much as consistently paying something toward their support.
Yeah, yes, Your Honor. There's been, it's embarrassing. There's been times I haven't had enough money to eat.
And that may be. I don't know.
Yes, Your Honor. There's other reasons I believe that are involved in why we're here today. And I've been trying to get an attorney, and it's very difficult. I mean, I've been to, called the FLAP and everybody else. Like you said, there's no saying that a lawyer who represents himself is representing a fool. If you're a non-lawyer, what are you? I mean, that's
well,
hard.
I can tell you that 90+% of our family court cases have at least one party without an attorney, and probably close to 80% of our family court cases have both sides without attorneys. And family court isn't like negotiating or dealing with complex medical malpractice issues or life and liberty. It does involve children, very important issue. But the courts are well adjusted to dealing with people who are unrepresented. And the issues of the non-payment of child support and what the child support amount is or should be are not that complicated. Question I do have of you, though, if throughout all of 2009 you were unable to pay child support, why didn't you come into this court and fill out paperwork on your own to seek a simplified modification or reduction in your child support?
Because I thought that I've always sought employment, and I thought that I would be able to catch and I would be able to do this. Circumstances have arisen that haven't allowed me to do so. My relationship with my ex-wife at one point in time was actually, I've kept her informed, by the way, Your Honor. I've never just said, I don't owe you. She's, it's been a very contentious relationship at times. I don't know if this is going to be the form, because like I said, I need legal advice, and I've been trying to find that, and I've been trying to actually talk to some people that could help me, but the amount that there's also issues as far as how much that I actually owe, and then
well, what I'm going to do, if Mr. Viles hasn't already asked for it, is I'll ask the Family Court Conference Center to prepare a report as to what father's child support arrearages are as of the date they prepare the report, and to provide me with a copy of that report, and if appropriate, I don't know if they can provide the parties or counsel.
They usually do.
Whatever. I'm going to ask that be computed. And it's usually right unless there's been payments made outside of the system. What I'm also going to do is set an evidentiary hearing, and then I am going to order the parties to exchange with each other and provide me with a copy, if they haven't already done so, of current affidavits of financial information. And that will require you, I believe, to exchange with each other your last 2 years, I think it's 2 years, the instructions are clear, of tax returns, your current W-2, 1099, and K-1 forms for 2009, and it also asks you to list your expenses and your income from all sources, gifts, trusts, corporations, stock, bonds, and employment. And I am going to order, let me get you a date first, but I'm going to order that within probably 30 days from today's date. So probably, I'm going to order that by May 5th. The parties will have exchanged current affidavits of financial information filed under or exchanged under oath subject to penalty of perjury, and will attach all of the required documentation. And you can get that form from the information or self-service center up front or from the computer online. I'm going to set an enforcement hearing, and if you feel you are entitled to a modification of your child support, I'm going to give you 2 weeks from today's date to file a petition for simplified modification of child support. And if you do that, I will hear, and provide a copy to Mr. Viles and a copy to me. I'll set that for hearing at the same time we set the enforcement hearing. So we'll take a look at what the child support amount should be. We'll take a look at what the arrearage amount is, and I'll determine whether or not there should be a contempt citation. There clearly will be an arrearage judgment entered, and then we'll set child support for the future at what it should be.
Yes, sir.
Yes, sir?
May I ask the clerk, there's issues of her actually, and it will come up, I believe that there's been some non-disclosure issues on her part that have to be addressed that I've discovered. And also there's a matter of payment where she has actually owed me, she actually owes me more than I owe her currently in the past. And that's what brought this up.
What does she owe you for that has any, under the divorce decree?
No, actually, sir, this was after the divorce decree was done. I had lent her a substantial amount of money, $10,000, and it can be shown. And also another $10,000, sir, that I had purchased, or I tried to purchase one of our homes back from her that she reneged on, and she's refused to pay. And I can show refusal, sir.
Well, essentially, what you're going to need to be able to do, and you're going to need to give Mr. Viles copies of any paperwork.
Well, isn't that anyway a civil action? If he's,
It may very well be, but I don't know whether or not he's contending, and I'm not speaking for him, whether or not he's given money to mother that should be treated as a credit against his child support. But clearly, if there are independent deals such as a loan that's properly documented, that's probably a matter to be resolved in civil court and not here, unless it's appropriate for the court to treat that as a payment of child support made outside of the clearinghouse. But I'm not going to resolve that here today, and I'll only hear the matters that are properly in front of this judge and nothing more.
yeah, that's just what I wanted to make sure of, because as far as we know, it's either going to be, it's my client's petition, and if he files a petition to modify, then.
Correct, but if he thinks he's entitled to credits because he's advanced mother or given her child support or monies by agreement in lieu of child support or as child support outside of, I'll take a look at it. But we're not going to relitigate the party's divorce now 9 or 10 years later. Yes, sir.
Well, sir, I recently came across some information regarding this, exactly what we're talking about as far as our division of assets and such. That is very, and this is what I believe is why we're here today, is this is why she's come after me now. I made some discovery that is very disconcerting, and it's a sizable amount of money.
Well, let me tell you this. I'm not resolving it today.
I know.
But if there's anything that you think needs to be considered, you better darn well make sure that you give Mr. Viles, your wife's attorney, full and complete copies of understandable documentation, and that might lead to some negotiations. But again, I'm only going to admit into evidence those documents or the testimony that relates to the issues that have been properly brought before this court. And if you're telling me that you're considering going on spending $3 or $4 or $5 or $10,000 on attorney's fees, I'd suggest that you might find a way to use that money to pay back child support. That all being said, I'm just going to give you a hearing date.
Okay, and Your Honor, just for the record, the only reason that my client has brought this action is because she hasn't been getting paid. There's no other reason for it.
Again, mother's motives. This court entered orders for child support. Mother didn't run here as soon as Dad missed one payment or two. She came here when he's missed at least 12 or more, and he never took these steps to file a petition for modification of his support if his financial situation has genuinely changed. So,
Sir,
that being the case.
I'm sorry, I didn't mean to interrupt you, sir.
Okay. Let me just get you here. I'm going to set it in front of me. How long do you think that we need? Do you think an hour would be sufficient, Mr. Viles?
Sorry?
Do you think an hour time?
I think an hour would be sufficient.
I think because all I'm looking into essentially is what has or hasn't been paid, the reasons why it has or hasn't been paid, and
I agree.
what the incomes of the parties currently are, and the
well, on the commissioner's calendar, we don't have any more time than that, and it's always enough time. So,
Your Honor, if I was going to file a separate action in, I mean, we can do it concurrently with this?
Well, I don't know what it is.
Oh, no, it's.
If there's a
custody-
civil suit on a promissory note that
No,
was
no.
post-decree, or on a loan,
No.
that's something that you gotta file in civil court, and I'm not gonna touch.
No,
But if you're asking to receive credits against your child support, I can't give you advice.
No, I'm not asking, sir. There's other issues that I need to take care of with her as far as custody, as far as
To file a
concerns.
petition, but that would be an hour
File a
hearing.
separate petition for those issues.
Well, if you file a petition this late for modification of custody or parenting time, we're probably not gonna hear it when we hear the child support-related
Right,
issues.
that's what I mean.
And I don't know, I haven't reviewed your decree. It might require, and I generally require, mediation or arbitration. Also, if you've waited this long with a 14 and 16-year-old to file a petition for modification of custody or parenting time, I'll view that somewhat with suspicion, because it wasn't filed arguably because it's in the best interest of the kids, but it might be filed in order to duck or avoid financial responsibility. But you have the right to file whatever you think you need to file. You just darn well better have a good faith basis for doing it.
I do, sir.
Okay,
Thank you.
just you file what you think you need to file.
Yeah.
I can tell you though that I'm not going to be able to get you in to hear custody issues up front. If I got a petition to modify custody and parenting time, there are some strict requirements under Rule 91 of our rules that need to be complied with, and there might be the requirement to order mediation before that takes place. You're a good probably, if that got filed, a good 3 or 4 months away from having parenting time and custody issues resolved. And I'd urge you to talk about those things independent of the child support concerns. Give me a date for a hearing. July 7th? At 10:30.
I'm good, Your Honor. I'm not there.
Need you both back here? Because this is a proceeding for enforcement of child support, Mr. Goodrow, you need to make sure you're back here July 7th at 10:30 a.m. And we'll mail you a copy of the court order, but you need to be here. Your failure to appear here could result in an issuing of a warrant for your arrest if you don't show up, and could also result in the issuing of a judgment against you, including a contempt citation, without you having the opportunity to defend yourself. So I definitely want to have you here. And if Mother didn't show up, I would dismiss her petition for enforcement. But if you don't show up, a warrant would likely be issued for your arrest.
Yes, sir. You said 3 weeks for the affidavit of financial? 3 weeks?
I think
Sorry.
May 5th is the
May
date
5th.
to
May
get
5th?
this. Yeah.
Okay.
That's about a month.
To exchange that information?
Yes, sir.
Okay.
Okay?
Okay.
We do stand in recess. Thank you.
Okay.